Gonna be a long conversation. Where did he throw it away?
There was a little bit left. I used
I know.
it. I disposed of the tray.
You what?
I used it. And then
you used it. Then okay, so it didn't stay on the tray.
This defendant walks into court already buried under a serious criminal charge, and instead of playing it safe, he makes a decision that only digs the hole deeper. While out on bond, he chooses to mess with substances he clearly had no business touching, almost like consequences weren't even on his radar. You'd expect someone facing this level of legal trouble to stay invisible and keep their head down, but he moved like the court would never connect the dots. His attorney is scrambling to control the damage, but you can feel the mood in the room shift the moment the truth surfaces. At that point, it stops being about excuses and starts looking like either a real addiction problem or a complete disregard for the justice system. Drop your thoughts in the comments. Does this look like someone who deserves another shot, or was this chance already wasted? Let's get into it.
Ready, Judge.
Yeah, Jonathan, I'm going to behalf of the people.
Court shall feature Assistant Public Defender, Mr. Walter LaCroix. Mr. LaCroix, please state your name for the record.
Walter LaCroix.
Thank you, Judge. I have spoken to Mr. Edmonds about this case. It's going to do some further look at the matter to see where we stand in terms of an offer. We're asking just for an adjournment for a couple of weeks of the PCC, and then I need to address his. It's not a bond violation yet, I don't believe, but it's a bond report. Where Mr. Croy given permission to test in Genesee County. He signed up for a program, DNA testing in Genesee County. That program did not release testing results to the community corrections unless he was positive.
Hold on a second. That's not what I have. Do you have his progress report?
The one that I have, I do have a progress report. I don't
from August 28th?
I don't believe that's the date. Let me check.
Mr. Allen?
Mine dated August 28th.
In terms of his testing, I have so he's here on an operating while intoxicated causing death.
That's correct, Judge.
All right. And on August 20th, after his arraignment, what day was he arraigned?
Arraigned on the 16th.
So then he got tested on the 16th he was ordered. He wanted to test there. He tests on August 20th, and he's positive for cocaine.
Correct, Your Honor. I'm aware of that.
Then, on the 22nd, he didn't appear for his testing.
That was when I was setting up to be tested in Genesee County. And I called the lady down here to let her know right away.
Let's go back a moment, because I don't think he's been before me.
I don't believe so, Judge. Just asking for a 2-week adjournment to see where we stand in terms of the potential.
Why is he testing positive for cocaine after getting charged and arraigned on an operating while intoxicated causing death?
Because he used cocaine, Your Honor. Obviously. I don't think he's...
No, it's a fair answer to my question. I'm just saying why.
Yes, Judge.
Why? I mean, why is he using anything?
Well, my understanding is he is not any longer.
What?
My understanding is he is not any longer, but he previously was. He began testing, transferred that testing to Genesee County per the instructions he was given at arraignment. He's been testing there, but they are not reporting the results here unless he is positive. They have not called him to test this week. He's called them twice a day to go test. They have not called him, so he went over today to community corrections, tested here, and he is going to change if the court allows him.
Tested here today?
Here this morning.
What is it? Do we have results on that?
I don't have it.
I don't have anything yet,
I was
Judge.
informed about it this morning myself.
So, go ahead, Mr. Green.
Thank you, Judge. So rather than do the Genesee County testing that authorized to do that does not send the reports as community corrections would require, he has signed up again today to test here and do all of his testing here, although he does not live here. He has a relative here with him who has agreed to drive him back and forth to do that testing, if he is allowed, Your Honor. I understand.
What was the intoxicant in the primary offense?
Okay.
So let me get this right. He's charged. I just want to make sure. so I have it clear in my head.
You do.
He was charged with operating while intoxicated, causing death.
That's right.
The intoxicant in that charge is cocaine.
That's right.
He's in arraigned, so now he knows what he's charged with.
Yes.
He's told to go to community corrections. When he gets to community corrections, mind you, 4 days later,
Yes. He tests positive.
he tests positive for cocaine.
I had some at my house, which I disposed of.
In your nose or what?
I had it in a tray and I disposed of it.
You what?
I had it in a tray
And then
I
you
threw
just
it away.
smoked it.
I threw it away.
You threw it away? How's that work? Where did you throw it? It's gonna be a long conversation. Where did you throw it away?
There was a little bit left. I used
I
it
know.
and I disposed of the tray.
You what?
I used it and then
Oh, you
of the
used
tray.
it. Then okay, so it
Everyone a
didn't
little
stay.
bit.
It didn't stay on the tray.
And I disposed of the tray.
Yeah. Yeah. Okay. Well.
And since then, I haven't touched it since.
What's that?
Okay. He probably stopped using because he was coming today. Yeah.
I'm printing them now.
You're printing him. So somebody needs to answer for me. Why was he using after being arraigned
I mean, obviously,
on this charge? And why was he using?
I
I
don't.
have my theory, Your Honor.
I don't think there's any answer to
Oh, darn.
satisfy the court as to why.
And by the way, you're still using.
This is the exact moment in the hearing where everything starts unraveling, all because he couldn't stay clean for even a short window of time. You can see him grasping for explanations, but every excuse sounds weaker when you weigh it against the seriousness of the charges hanging over his head. His lawyer looks completely boxed in, because there's only so much damage control you can do when your own client keeps making things worse. And Judge Simpson is not someone who tolerates games with bond conditions, especially in a case this severe. What really stands out is how casually the defendant is treating it, like this is some minor misunderstanding instead of a massive violation. People forget that bond isn't a right, it's a privilege built on trust, and the court only extends that freedom if you follow the rules. He didn't just bend them, he broke them almost immediately. So be honest, does this look like someone who deserves another chance? Because from where I'm sitting, that window feels completely closed.
Honestly, I don't see how. I
Oh,
have,
really? Hold on.
I've never worked
You know
on
what?
that.
The thing I hate more than anything is when somebody lies to me. Counsel, approach briefly. You want to see this?
Judge.
That's my copy, though. Yeah, this is the one he took today. No, not at all. We need all of this on the record.
And the last positive from the second to 7 days later.
Yeah, 7 days later. And a little bit he threw away. That. Go ahead. I'm sorry. I'm messing up your story.
To answer your previous question, Judge, why?
Oh, he's positive for cocaine.
Judge.
Just
And
so that we know.
thank you, Judge. And to answer your previous question as to why he's still using after being arraigned,
Sure.
clearly he has a problem, Your Honor. There's no answer I can give you that can justify use of cocaine after arraignment when it's an illegal. He doesn't have any type of special license to allow him to use cocaine, Judge. So clearly he has a problem. He is willing to fix that problem. He is working, and he did voluntarily come here today and take a test. So he's asking you to not say that.
Right. No.
No, you have to stay.
Right. Anything else?
All I can say, Your Honor. So to the positive test, Your Honor, I have no explanation aside from what he already told you.
Which positive test?
The
first one or this one?
The first positive test. Your Honor.
Oh,
The explanation he gave you is that he used it and then threw away the tray. After he was arraigned, after he was ordered not to use, have no explanation, Your Honor. He'll just ask for mercy from the court on that, and he is willing to get any treatment that the court would allow him to take place.
because that he can't follow the court's order. I don't know how he's going to do treatment. And the other thing is, he doesn't test when he's supposed to test. So it seems you may have two options. I could let him go and say, oh, well, best wishes. Or what I can allow him to do is go back out there, use some more cocaine, and kill somebody else. I'll let you know. Not doing it.
Understood, Judge.
Defendant's bond is revoked. Defendant remanded to the Washington County Jail. I'll set his hearing September 12th, 2024, 9 a.m. for probable cause.
9/12?
9/12.
That entire hearing is a textbook example of how quickly everything can collapse when someone refuses to respect the court process. You can actually see the judge trying to extend some patience early on, but the justice system only stretches so far when its rules are ignored at every turn. What makes situations like this especially tragic is that the damage spreads far beyond the courtroom. Families, victims, and even the defendant himself all get pulled into the fallout. And the reality is a lot of people don't end up locked up because of their original charge, but because they couldn't handle the responsibility that comes with being out on bond. Once the court's trust is broken, the system tightens up fast, and second chances become rare. At that point, it stops being about punishment and starts being about protecting the public. Hopefully, he gets his act together before trial, because the road only gets harder from here. So what do you think? Did the judge make the right call shutting this down? Or would you have risked giving him one last chance?
I have no issue testing, Your Honor.
You sit up here telling me you don't have an issue testing. I've got 2 missed tabs.
Hands down, it's just because of the time.
The defendant was arrested in possession of 56 pills of Adderall.
I'm not trying to skate. It's hard. It really is hard. I got my kids. It's just hard.
May he take a sick day and test tomorrow morning first thing?
No.
Okay.
Counsel, you probably should stop talking too. I can't get him in because of time.
Well, he said by 4:30. Oh, sorry.
This defendant steps into Judge Simpson's courtroom acting like he's got an answer ready for every problem thrown his way. He insists he's clean, yet somehow keeps accidentally missing drug tests while on probation, which is never a good look. According to him, work schedules are the real culprit. But that explanation starts falling apart fast in a case where every missed test is a flashing warning sign. You can see the judge's patience thinning as the story stretches further and further from reality. What really stands out is how confidently he delivers these excuses, like confidence alone is supposed to cancel out probation rules. Some people honestly believe that if they sound convincing enough, the court will just ignore the paperwork and the pattern. So what do you think? Does this explanation hold any weight? Or is he just trying to talk his way out of trouble one more time? Let's get into it.
Judge Mark Ellis representing Randall Jolly. Sir, please tell the judge your name.
Randall Jolly.
Your Honor, this is a PCC. We're requesting an adjournment of that, but as the court is reviewing, we have a bond violation.
Yes.
May I address the bond violation? Your
Yes,
Honor?
please.
Your Honor, I was not the lawyer on the record at the time that the arraignment was happening, so I wasn't there, didn't know about it. I did review it this morning. The bond document in the file does not order my client to be subjected to testing. It tells him don't do drugs. Now, I don't plan to use that.
Well, but counsel, go ahead. You can.
I don't plan to use that as my.
But go ahead.
Not a problem. Judge, the problem is really the past and going forward. He tested positive for a drug which is a opioid inhibitor. That, of course, is a drug you cannot get and you cannot take if you are taking opioids because the combination of the two is likely to kill you. He has a prescription for that. So the funny sounding buprenorphine. Yes, he has a prescription for that. He today can pull out of his pocket a copy of his pill bottle showing his prescription.
Well, he pulled out grabbing it out.
So, Judge, I have that available to the court.
He's on Suboxone.
He is.
Okay.
Yes, Judge.
Can I say?
Shh.
But you're saying he didn't know that he had to test?
No. That is not my argument. But Judge, going forward, I believe there's a problem. He has missed the last 2 tests. The only reason he missed the last 2 tests is he is employed full-time at Ford Motor Company. He has his employee badge in his pocket. If you can pull that out, we will offer that to the court. He works a crazy schedule. He builds cars, and he starts at 6 a.m. and he gets out at 5 o'clock at night. His testing facility closes at 4 o'clock at night. He's been there 5 years, but he doesn't have the sort of seniority to grant flexibility. So we apologize for missing it. So this morning, when I had no idea that there would be a bond
What
by
was the other drug, the amphetamine?
that was the initial time, Judge, and he's absolutely guilty of that. That was the first time he was ordered to test.
Yes.
Since then, he has not taken any of that stuff, and he will test negative today.
Well, there are two things. One, he had THC in his system.
Yes.
Whether he took it or not, he doesn't get a card till the next issued the next day.
Yes.
He also has abnormal creatinine, which is a problem because that usually will appear in rare circumstances, but typically when somebody's trying to mask.
So Judge, if I may, he absolutely flunked your first test, no question about it. But that was the first test, and since then he has been clean. He missed the 2 tests.
I don't know how you say that. He took one other test.
Yes.
And then didn't test.
Yes.
That's.
Your Honor, may I say something? I'm sorry to interrupt. I just wanted to say something on my behalf.
Go ahead.
I live in Wayland. I work in Wayne. It's a 2-hour drive. I drive literally 4 hours a day back and forth to go to work and get back home. I work till 5 o'clock. I called my probation officer. I want to test. It's not that I'm trying to get away from testing. It's impossible when it's at a time I can't get there. And I don't want to lose my job because that's some benefits for the kids. I mean, it's a rock in a hard place situation. And I'm just trying to figure out the best way to move forward without losing.
Did you talk to your attorney about testing closer to where you are?
No, Judge, I had no idea there was a problem, but I will say this. When I found out this morning there was a problem, I called testing facilities.
Yes.
And I found places that have more relaxed hours. They also charge $130 to $150 for a test. At the moment, your court's charging them $12. And I mean, that is.
I don't mind paying the money. And it's the facility closed at 4, I just get off at 5. I have no issue testing, Your Honor. I really don't.
Well, when I look at this, you sit up here telling me you don't have an issue testing. I've got 2 missed tests.
Correct. I have an issue because of the time, Your Honor. That's it. I'm hands down. It's just because of the time. And I'm not trying to skate. It's hard. It really is hard to get out of my job. It's an assembly line, so they can.
I understand how.
I want to fix this. I do. I really do.
I don't know what it is about this guy, but something about the situation just feels off. You don't miss 2 drug tests and then walk into court brushing it off like it was a simple calendar mistake. That's not how probation works at all. I understand people have jobs, families, and real responsibilities, but when you're one misstep away from sitting in a jail cell, everything else should take a back seat. Watching him explain himself, he talks like this is all totally routine, and you can almost sense the judge waiting for one wrong word. The strange part is he looks genuinely nervous, yet he's still trying to sell the idea that everything is under control. That's usually a sign someone knows they're on thin ice. It honestly blows my mind how many people underestimate how unforgiving these programs are until they're standing in a courtroom under pressure. If this were me, I'd have alarms, reminders, and backup plans stacked on top of each other. What do you think? Does this feel like an honest mistake? Or does it come off more like conveniently forgetting when it matters most?
Well, and I don't know why somebody's not contacting the court or somebody prior to us getting to this point today. Then when you know you haven't tested.
Sorry, Judge, I read the email this morning. I had no idea there was a problem.
I'm fine.
And it would be one thing if all that was showing up in a system is Suboxone, but that's not everything that's showing up in a system from the initial test. And then I really don't have much for August.
I'm sorry, I didn't.
I don't have testing for August. I mean,
Yes.
effectively, I don't have it. The whole month.
Understood.
He doesn't test.
I want to, Your Honor. I do. I just need a facility that's a little later. I'm just scared to lose my job. It's really, I got my kids. I mean, it's just hard.
Judge, had I known, I would have made efforts to try to resolve this before today. I have no idea this was coming
I
up.
just need a little help.
Any response from the people?
Your Honor, I'm trying to sort it out. My concern stems from the fact that this offense date was July 2nd of 2024, where the defendant was arrested in possession of 56 pills of Adderall.
Anything else?
Judge, I wish there was an easy answer.
Your Honor. Yeah.
If the court allows, he will spend $150 and test at a private clinic.
Could have done that
Yes,
before.
absolutely.
That's my point.
You're
My
exactly
point
correct.
is he could have done that before.
Yes.
There is nothing that prohibits him from doing that. What I have and what the prosecutors added is that the only test I have is that same drug that's showing up a year past is still showing up in his system. And then I don't have any testing.
True.
Simple as that.
You don't.
If it's all one, I really did. My probation officer, well, she'll tell you. Fine, you're
Will
sorry.
the court test him today?
I can't get him in because of time.
Well, he said by 4:30. Oh, sorry. Sorry, Your Honor, I'm sorry.
And find out if they can test him right now. If you come back dirty,
I won't.
I am putting you.
I have not taken none, I swear.
You know what? You need to be quiet about now. Can you see if they can get him tested?
Yeah.
He will test positive for the opioid blocker. Prescription, he takes it.
I understand that, Counselor. You probably should stop talking too.
I'm not good at that skill, Your Honor.
I know. You need to go over there, see if you can test. You
You
don't
shall.
get tested, you're gonna go.
So, Your Honor, may he take a sick day and test tomorrow morning first thing?
No,
Thank you, Judge.
I gave you your options. Go over there and test. If they let you in, fine. If not, you still gotta come back here.
Sir.
And if you don't test, you're going.
Thank you, Judge.
Bye.
Your Honor, Mark Ellis representing Randall Jolly. Mr. Jolly, tell the judge your name.
Randall Jolly.
First thing that I'll do is I will adjourn the probable cause conference to the 18th, 2025, 9 o'clock. His test came back. He's positive for the marijuana. He did get a medical marijuana card the day after he first tested positive for marijuana. I'm going to suggest that you probably start or cease using that. But I have negatives on everything else. So what I will do is I'll continue his bond at this point with the admonition that if you miss another test, I'm not hearing argument. You're going. Simple. And then the other portion of that is that I will allow defendant may test. What county is that if you live in?
Allegan. Allegan.
I'm a Michigan resident.
I'm sorry.
He may test in Allegan County at an approved facility by the Community Corrections.
Your Honor,
His test results, he must sign a release so that his test results are sent to Community Corrections.
Your Honor, if I may, first of all, thank you. I appreciate it. My condolences on this docket of yours today. Judge, in the interim, my client contacted his boss at work. It is possible that he can test at the Ford Motor Company. Evidently, they have those facilities in some way. If that can be arranged, that's good enough.
That if as long as Community Corrections will approve the testing and the manner of testing, I'm not so concerned. But those results must be released to Community Corrections so that they can be
Certainly.
reported to the court. So he'll have to execute the necessary releases.
I'd be happy to do that. Do we have any idea who I would contact at Community Corrections?
I do not. So what I
Okay.
suggest is you call over there, indicate his name.
Yep, very good. Thank you, Your Honor. Have a good afternoon.
I'm going to be honest with you all. I'm still raising an eyebrow at those clean results after everything that just played out. Sure, he passed today, but missing 2 tests beforehand gives someone plenty of time to make things look good on paper. You could tell the judge was already exhausted by the situation the moment the attorney started pulling out explanations and visual proof, like the court was supposed to ignore the pattern leading up to it. Cases like this really highlight how razor-thin the line is between catching a lucky break and being in custody before the day's over. This guy came dangerously close to jail, and that alone should be a wake-up call. That said, I've got a feeling this isn't the last time we see him in a courtroom, because missed tests have a way of repeating themselves. We'll have to wait and see how this plays out. Let me know in the comments if you think this scare straightened him out or if another slip-up is right around the corner. And if you want a part 2, when this case pops back up, make sure to subscribe. Thanks for watching. Hit like if you enjoyed the breakdown. And as always, take care.